Good evening. Welcome to the evening edition from day one. Where we left off is where we pick up here in the new Dominion.
Hool versus Jason Hool, case number 23 AP 078.
This is just all kinds of innocent and charming, honestly.
Appellant James Hool is self-represented and has not appeared. Appellee Amanda Hool is self-represented and is appearing by WebEx.
Well, Ms. Hool, can you hear me?
Yes.
And we can hear you. Is there anything you want to say?
Do I need to speak my argument or
Yeah.
just
Do I need to speak my argument? Yeah, we're here for oral argument. That's how that works. It's charming. They try to make her feel good.
Chief, can I just tell one quick war story? The first time I went to the Second Circuit, the appellant was a lawyer from New York, and he didn't show, and the Chief Justice from the Second Circuit said, "Is there anything you want to say?" And I said, "Well, I've come all this way. I'd like to say something." And so that's I use that as my standard here. So, like,
if I don't need to say anything, I don't want to say anything, but I have prepared my argument.
Well, please go ahead. I think you certainly have made an effort, so we would like to hear what you have to say.
Okay. So I'm reading it. Is that okay?
Oh, sure. Yeah.
Okay.
Oh, good Lord. I mean, it's horrible by legal standards, but it's very sweet. It looks like she's making a speech at the PTO or something. But it's cute.
I'm shaking. Your Honors, these motions have been filed and matters heard and ruled on by a superior court. Originally, we both had attorneys to oversee the processes. From what I understand, the courts have used other cases and the Vermont statutes for their rulings. These matters have been applied and brought back to Superior and then Supreme Court for the review of the findings.
Well,
you
yeah.
have our briefs and have access to previous motions and findings. Although there are times we may not agree on the rulings, the law has been applied. My children and I have been through a lot since the decision to file for divorce. I never planned to sell my house, ever. However, I am grateful that I was able to get out from under all the debt. We all make decisions and choices, whether it's to move, change jobs, or whatnot. Start over in new relationships. None of this has been easy on anyone involved. I may not receive the court-ordered spousal or child support that I expect from my former spouse that has been court-ordered, but I am grateful for what I do receive. None of this has been easy on anyone involved. In closing, I would like to thank you for your time and opportunity to speak, and I'd like to close this chapter of my life, and I hope that Jason Hool or Mr. Hool would do the same.
Well, thank you very much. Thank you very much. We appreciate your appearing here and appreciate...
All right, people are really into this. In some places they call it the Parent-Teacher Association. Some places they call it the Parent-Teacher Organization. It's an acronym. It's common both ways.
what you said. So, since the other party to this case has not appeared, and you've had a chance to speak your mind about the matter, we'll call a conclusion.
All right, there we go. There we go. That was fantastic. All right, now I haven't seen this either. Let me see if I can get this going here. I'm told we have a sovereign citizen here. Just in case, I'm going to put my thinking cap on to kick this thing off.
in the matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, counsel, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
Doesn't look, he's out. Yeah, he came out and went back in.
Yeah, you have a phone. Mm-hmm.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the
Well, the first thing I
prosecutor.
want.
You
Okay,
want
the
a
first thing I
trial
request-
today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere.
It's official. There it is.
I was asking for the same thing up in the Clarkston courthouse, and they sent me to the
Well,
Oakland County jail.
Mr. Lanto, I'm not gonna produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say, but first,
Okay, so you want the 30 days.
First thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just
say?
Can you?
I haven't
clarify
sent
something for me?
this to the assignment clerk, Mr. Lanto. You're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all, and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What do you say? No.
Have you calmed down a little bit? Oh, the only thing would have been better is if it was a female judge.
You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you leave the meeting. We'll see you in 30 days or so.
Let's discuss your feelings, Mr. Lanto.
Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts, and nobody has said I'm talking crazy.
I did. Law Talk with Mike said you're talking crazy right now. You've asked the same questions in other courts. Some choose to ignore it. Some choose to tell you to your face that it's stupid. This guy went the second route. It was enjoyable.
Yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh.
All right, Judge makes number 2. Law Talk with Mike here makes number 3. So look at that. You've tripled in one day.
That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And
That's
then number
why we're
two,
asking for discovery.
okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no, the proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
well, I feel like I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
scariest.
This judge is just killing it. I love it.
You watch over him when he comes.
That is the scariest thing I could ever hear. And that's coming from a very
yeah, dummy. That's he's well aware of the statement he just made.
Reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you, and you come into court, and we'll take care of business. Okay.
So what does it mean to take care of business? And I got to come in person, and you're going to assign a police officer to me, and then you said I'm talking crazy.
No.
I'll tell you what. Don't show up, and you'll find out what it means.
Did I just recall what was said on the record? Did I just recall that correctly?
You said no. You said it in reverse. I said first that you're talking some crazy talk. Then I said I'm going to adjourn it for 30 days, and then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days. People versus William Vaughn. Mr. Vaughn here.
Yes, sir.
Mr. Vaughn, can you hear me?
Yes, I can hear you.
Well, there you have it. On the fly, because I'm a fly attorney. I'm not the fly attorney. I want to give credit where credit is due. The fly attorney, as far as I can tell, is an attorney somewhere in Georgia. I'm merely an imitator. I just got a fly attorney costume. I make no pretense otherwise. But it was perfect for today's purposes. It really was. It really was. Thank you all. Thank you all for coming out. Thanks for telling me about the subset midstream. That couldn't wait. That had to happen. And we got it done. All right. Thank you all for coming out. I will see you all soon.